The topic today is
Just hold on. Let me start on the YouTube. Article 300A of the Constitution of India, where it is laid down regarding right to property, is a theme or what we say topic, wherein Mr. Ameet Kumar Deshpande, a senior advocate from High Court of Karnataka, Kalaburgai bench, is going to take us for the deeper insights. And today's session is in collaboration of Beyond Law CLC and Thiruttam and Associates. As usual, Mr. Deshpande has been kind enough to share his knowledge. Thank you, Mr. Pandey, for accepting our invite, and over to you.
Thank you, Mr. Vikas, and thank you, Mr. Vikram. Thank you, all other associates. The topic today given to me is Article 300A of the Constitution of India, right to property. Now, Article 300A of the Constitution of India reads thus: no person shall be deprived of his property save by authority of law. Though the words seem to be simple and short, yet have one of the greatest impacts on the lives of people in this country. Before we understand what is Article 300A, let us all understand the historical evolution of this right to property. As you all know, property is one of the dearest acquisitions or possessions that a man has ever held. Before the right to property was formally recognized under the Constitution of India, we can find in this country a reference to the right to property under the Government of India Act 1935, which is a pre-independence enactment. Section 299 of the Government of India Act 1935 had recognized the right of property of persons in this country, and the then British government was given certain restrictions to meddle with such right of the property of the persons residing in this beautiful country. When the Constitution of India was adopted, Article 19, 1F of the Constitution contained, among several other rights, the freedoms, the right to possess property. Similarly, Article 31 of the Constitution of India, as originally enacted, also contained rights to property of the citizens or persons of this country and certain restrictions on the actions of the state over such property. By the 44th Amendment to the Constitution of India, the recognition of right to property as a fundamental right was taken away, and Article 300A in Chapter 4 of Part 12 of the Constitution was inserted by deleting Article 19, 1F and also by substituting Article 31 of the Constitution. By virtue of this 44th Amendment to the Constitution of India, the fundamental right to property was abridged, and it is now recognized as a legal right under the Constitution. And therefore, as on today, though right to property is not a fundamental right under the Constitution of India, yet It is a constitutional right of the persons of this country. This is the brief historical evolution of the right to property under the Constitution. However, if we go back to history, history is vast enough to give examples of how right to property was recognized, has been protected, has been agitated by, in the ancient era, by the people against the king or by the king against another dynasty. All that would be too much for us in this lecture to delve deep into. For the purpose of knowledge, for advocates and students of law, this much of introductory historical evolution to the right of property would be sufficient, is what I assume. We have to understand one important fact, that property as a term, as a concept, has not been defined. So we have to rely upon the common understanding of the term property. It is very difficult to define the term property or the concept property in a straitjacket formula kind of a thing. However, I was able to lay my hands over a few treatises, one of which is a classic for the students of law, Salmond on Jurisprudence. In his 13th edition, in chapter 13, it is said, a man's property is all that is his in law. What I mean by that statement is that at one particular point of time in the human experience, one may define and probably conclude the list of what all things might be included in the term property. However, it would be a changing definition by the change in the era, by the change in the circumstances, by the change in the advancements of human life. And therefore, it is also not, in the present scenario, very apt to give a strong definition to this term. Nonetheless, we can understand the concept of property with reference to few things. By property, as I have understood, we mean anything that is tangible or intangible, that thing which can be owned or possessed, which includes its rights and interests associated with the ownership. All those things can be treated as property, is what I assume. The law, rather, would accept such a definition or meaning of the term or concept property. Property has been divided into, or can be divided into, material things and immaterial things, movable and immovable property. As understood, the property can be land or chattels, classified as corporeal property. Property can be patents, copyrights, trademarks, etc., which can be classified as incorporeal property. Concept of property is ever elastic, and human experience will pave path for an endeavor to bring within the scope of the meaning of property many other ideas. I am making this statement especially in the light of the technological advancements that we are seeing. As for example, I will refer to a judgment of the Honorable Supreme Court in the course of this lecture, where the Honorable Supreme Court was confronted with the argument as to whether the right to privacy should be treated only as property, or should it be treated as not just a legal right, but a fundamental right. So there could be an era in future where something like data related to me or data which I have accumulated belonging to someone else would be a property or not, will be a hotly debated concept. So therefore, what we have to start with while understanding the theme underlying Article 300A of the Constitution of India is to know that property as a concept is elastic, and only human experience will be able to give the changing definitions to that term and concept. When I say anything that humans can possess, or anything that is his in law, is property, we also need to know, as a student of law, what are the modes of acquisition of property. As you all know, there are more than one modes of acquisition of property. A complete list of the titles or modes of acquisition of property would not serve any purpose, as even that would be an ever-changing thing. Nonetheless, classically, what has been known and recorded in the treatises are these: possession. One mode of acquisition of property is by possessing that material object itself. The possession of the material object is itself a title to the ownership of that object. We will find such inferences not only under the principles of common law, but evident from the Evidence Act, from various judgments of the courts, which have said that yes, possession is title to the ownership of the object. It is elsewhere said that possession in law is 9 out of 10 points. That's why we all, as students of law and as practitioners in the courts of law, tend to first lay before the court evidence establishing the possession of a particular property for the purpose of establishing the higher right or the larger right of ownership or title to the property in several suits. The next mode of acquisition of property is by prescription. By prescription, I mean the effect of lapse of time in creating or destroying rights. It is the operation of time as a vestitive fact, which can be positive or acquisitive prescription, and it can be negative or extinctive prescription. Friends, I am not trying to explain something new for you people. I am simply borrowing something which has been explained by erudite scholars, authors in their works. So therefore, pardon me if I am not being original here. I am not original because I am greatly influenced by the brevity, the sharpness by which such scholars have explained these concepts in no time. And that's why I borrow their works, so that we all here can understand those concepts clearly. After possession and prescription, one other mode by which property can be acquired is by agreement. And agreement, I do not mean merely contracts, but all bilateral acts in law expressing the consenting wills of two or more persons to an alteration of their legal relations. So, by agreement, one can acquire property. By possession, one can acquire property. By prescription, one may acquire property. All these will tend to be titled to the property. The last in my list is that mode of acquisition of property, probably, which is the strongest and which has breeded the highest number of litigations in the country and elsewhere also. And that is inheritance. Simply stated, it's the rights that survive after the death of the owner of that property. And how inheritance happens is again a subject matter of a different topic altogether, which can be dealt with as a separate lecture for the better understanding of the legal concepts of that inheritance. But essentially, these are the four modes of acquisition of property. Since the time given to me is short and the topic is so vast that it is hardly possible for anyone to complete the entire topic in few minutes or maybe even in an hour. But I may mention here, before I go to the next important aspect of emphasizing few important judgments of the Honorable Supreme Court. See, what has been stated under Article 300A of the Constitution is this. It says, persons not to be deprived of property save by authority of law. That is, no person shall be deprived of his property save by authority of law. Now, we have made an attempt to understand what is the meaning of property here. We have also to understand what is the meaning of except by authority of law. If we all have time, please read the provisions of Article 19(1)(f) before the 44th Amendment to the Constitution of India. Also read the provisions of Article 31, the unamended provision of 31 of the Constitution of India before the 44th Amendment to the Constitution. That will show the stark distinction between the words used in Article 300A and the earlier Article 31(1). There have been several enactments enacted by various states, the parliament, and the effect of such enactments sometimes has been that the enactment itself runs contrary to certain other fundamental rights enshrined under the Constitution of India. And therefore, such enactments, when challenged before the Honorable Supreme Court, that also there are certain legal principles that have been emanating from such judgments. We all also need to understand such principles so as to understand what is the understanding of the right to property from the perspective of the judiciary. One very important enactment is the Land Acquisition Act 1894. Now, the Right to Fair Compensation, in short, 2013 Right to Fair Compensation Act. Those two enactments are enacted especially with the view of balancing the right of a citizen to hold property and the right of eminent domain which the state can exercise. What has been accepted throughout the judicial history of this country is that no person can be deprived of his property subject to two conditions being followed. One is that the deprivation of the property at the instance of the state or its authorities shall be for public purpose. And two, that upon such deprivation of property, the person deprived of the property shall be held entitled for compensation adequate compensation, appropriate compensation. Therefore, the right to property also includes within it not only the substantial right to hold property, not only the substantial right to seek compensation or to get compensation, adequate and appropriate, once it is deprived, only upon the fulfillment of certain conditions as enshrined under the enactments, but also inherent in this right is the right for a fair procedure to be followed by the state before the landholder is deprived of his property. And this procedure itself, I may say, is the procedural right or the procedural safeguard itself is a substantive right under Article 300A. Now, the classical understanding of law from the perspective of a trial side practicing advocate is that if you are deprived of your right, you can always, under common law, approach the civil court, seek for appropriate damages or compensation, and therefore file a civil suit. However, the question that has come before the Honorable Supreme Court and various high courts several times is that if the state extends its arm beyond what law permits and deprives or does any action or deed which has the impact and consequence of depriving or affecting the right to property of any of the citizens in the country, would that person have the remedy of approaching the High Court under Article 226 of the Constitution of India? Or is the remedy to approach the civil court seeking appropriate damages or for an injunction or a mandatory injunction or recovery of possession? What is the remedy that is available to a person? Now, the judgment in the case of Syed Maqbool Ali versus State of Uttar Pradesh of the Honorable Supreme Court, reported in AIR 2011, Supreme Court page number 3430. Supreme Court page number 2542. The Honorable Supreme Court has held that the remedy of a landholder whose land is taken without acquisition is either to file a civil suit for recovery of possession and for compensation, or approach the High Court by filing a writ petition invoking the jurisdiction of the High Court under Article 226 of the Constitution of India, if the action can be shown to be arbitrary, irrational, unreasonable, biased, mala fide, or without the authority of law. And then, in such petition, to seek for a direction that the land should be acquired in a manner known to law. It has come to the experience of many of the advocates practicing the courts of law that sometimes the state and its authorities would, in the best example I can give is when roads are tried to be widened, of course for public purposes only, of course for the convenience of the greater good of the public at large. Nonetheless, while the roads are widened by the state and its authorities, the private properties of individuals are affected adversely. The values of those private properties are diminished, reduced, or sometimes the entire property is lost in that widening process. What happens is that the state and its authorities, maybe due to paucity of time or many other valid reasons could be so, nonetheless, would not issue a notification of acquisition as prescribed and mandated under the relevant statutes. For example, the Right to Fair Compensation Act 2013, in short, if I may call it so, or the earlier Land Acquisition Act, or several other requisition enactments and other enactments. There are certain procedures required, especially the procedure of notifying the person that your property to this extent would be taken away by the state for a certain purpose, which is or should be a public purpose. Now, if a property, say, for example, the widening of road, the private property of a person is taken away, but no notification is issued, then, or once the notification is not issued, then other mandatory procedural prescriptions under the Land Acquisition Act or the relevant enactments will not be certainly followed by the state and its authorities, and therefore there is no guarantee that the citizen would be given the appropriate compensation or would be given an opportunity to have the remedy before the appropriate forum to agitate his right to seek appropriate compensation. And therefore, in such cases where the procedures prescribed under several enactments is not followed or is violated, the Honorable Supreme Court has held that remedy under Article 226 of the Constitution of India can be availed directly before the Honorable High Court. And one need not always go before the civil court, file a civil suit, and only seek for the relief of recovery of possession or for damages or compensation there. This has been held by the Honorable Supreme Court in the case of Syed Maqbool Ali versus State of Uttar Pradesh, reported in AIR 2011, AC 2542. However, we have also the experience of seeing that citizens approach the Honorable High Courts under Article 226 of the Constitution of India, stating that their private property has been deprived of by the action of the state, by the excess of the state, but such excess has happened allegedly several decades ago or several years ago. Now, that is a situation which will have to be taken note of by the Honorable Supreme Court while permitting a citizen to invoke the provisions of Article 226 of the Constitution directly before the High Court for the purpose of seeking compensation or for the purpose of directing the state and its authorities to acquire the land by following the procedures required under a particular enactment. In a case very recently decided on the 24th of September 2024 by the Honorable Supreme Court, in HMT Limited versus Rukmini, the Supreme Court has held that in the state, referring to an earlier judgment, a 3 judges bench decision, in the case of State of Maharashtra versus Digambar, a 3 judges bench of the Honorable Supreme Court had observed that the grant of relief by the Constitutional Court under Article 226 of the Constitution, without considering the blameworthy conduct such as delay and laches, would be unsustainable, even if such relief was granted for the alleged deprivation of a legal right. It is held, discretionary relief in such circumstances can only be obtained upon fully satisfying that the delay was justified and explainable. So, my dear friends, while we have multiple remedies available in law, approaching the Honorable High Court under Article 226 is one of the remedies that has been approved by the Honorable Supreme Court. Nonetheless, what has to be kept in mind is that it has to be shown that there is no unreasonable, unexplained delay in approaching the Honorable High Court seeking the relief from the High Court. So this is one such caution that was also made in the case of Syed Maqbool Ali versus State of Uttar Pradesh, where the Supreme Court in that case held that yes, one cannot go under Section 18 of the then Land Acquisition Act 1894 before a reference court, before a civil court, when there has been no notification under the Land Acquisition Act for deprivation of the property of a landholder. and therefore the appropriate remedy is only to approach the Honorable High Court under 226, or alternatively also to file a civil suit for recovery of possession and for compensation. However, the caution mentioned therein also was that if the High Court has to exercise its discretionary power under Article 226 of the Constitution, then it has to assure itself that there is no delay on the part of the petitioner before the court. There are no latches on its part. The reason obviously is that, say for example, if a petitioner has to approach the High Court alleging that some 45 years ago or 50 years ago or 30 years ago, he was deprived of his property or land by the state and its actions and its authorities, it will be hardly practically possible for the authorities to ascertain the documentary proof of such alleged deprivation of property. And therefore, delay and latches have been a factor for the High Courts to decide, as has been explained in these two judgments. There was a very interesting case before the Honorable Supreme Court arising out of a judgment of the Honorable High Court of Karnataka in the case of KT Plantation versus State of Karnataka, which is reported in the AIR 2011 SC page 3430, where a particular enactment itself was under challenge. Various principles of law were discussed, debated, and laid down by the Honorable Supreme Court in this judgment. It will certainly make a very interesting reading for all those constitutional court lawyers. However, for the purpose of what I have been explaining in this context, what is importantly held amidst several other principles in this judgment is that public purpose is a precondition. Public purpose is a precondition for deprivation of a person from his property under Article 300A. And the right to claim compensation is also inbuilt in that article. And when a person is deprived of his property, the state has to justify both the grounds which may depend on the scheme of the statute, legislative policy, object, and purpose of the legislature, and other related factors. Statute depriving a person of his property is therefore amenable to judicial review on the grounds that has been discussed in the said judgment. This is the short of what I could emphasize for the purpose of the context in which I am mentioning this judgment. So please understand what has been understood and held in the case of KT Plantation is that there are two preconditions. One is public purpose is a precondition, and that the right to claim compensation is an inbuilt mechanism or a right under Article 300A. And if a statute that has been legislated has to be tested and stated to be valid, then both these grounds have to be established before the court. And that depends on the very statute, it's the very object, the purpose of the legislature, and other relevant factors. What has been emphatically stated is that, yes, legislative actions are also amenable to judicial reviews on the grounds which are permissible as stated in this judgment. The most important and landmark decision of probably that decade is the judgment in the case of K.S. Puttaswamy versus Union of India, which is reported in 2019, volume 10, SCC, page 1. That was a case where the question as to whether right to privacy is a fundamental right. Is that a right to property? Is it only a legal right? Several such questions arose before the Honorable Supreme Court. The Constitution Bench of the Honorable Supreme Court held that yes, right to privacy is a fundamental right. This is where, friends, I say that as lawyers, as advocates, we all need to have that intellectual quest to see not only what is the law that has been laid down until now, but also to foresee what could be the law in future. How can we develop the law from the foundations of what is made available to us till now? Therefore, there are it would be hardly possible for me to enlist what all kinds of things in future can be treated as property. Since this is one case in the judgment of case Puttaswamy versus Justice case Puttaswamy versus Union of India, which had the occasion to discuss whether right to privacy, whether the data relating to the personal data of people, all this can be only property or not. That is where we all can continue to think, ponder over, and then assist the courts in future in bringing into the concept of property several ideas, and novelty is one which is required for all advocates. And these kind of lectures shall become a medium for all of us to go home, keep thinking about how we can contribute in enhancing the quality of life of the people in this country by assisting the courts with our understanding of law and our contribution in the courts of law, in the honorable courts rendering effective judgments, expanding the scope of certain other things to come within the purview of the concept of property, so that those things, those possessions can also be protected under the Constitution as a constitutional and a legal right. I will come to the next decision, which will be the last decision in my discussion today. This probably is one of the finest decisions rendered by the Honorable Supreme Court in this decade on the right to property. The Honorable Supreme Court, after discussing the facts of this case, has also very intelligently pointed out several sub-rights of the right to property. Now, the important sub-rights that have been expressly mentioned in this judgment, in the case of Kolkata Municipal Corporation versus Bimal Kumar Shah and others, this is reported in the neutral citation 2024 INSC page 423. Those sub-rights noted in this judgment are these. Firstly, the Honorable Supreme Court has expressed that right to property is a net intersection of rights. It's a web of rights, not a single right, but it's a web of rights, which includes these procedural sub-rights, and those are the right to notice. Notice in the sense, the right to be notified that yes, you will be deprived of your property for certain reasons, certain purposes. Then, a very important right to be heard. My dear friends, please recollect section 5A, 5 capital A of the Land Acquisition Act 1894 and the judgments rendered by the Honorable Supreme Court on section 5A of the Land Acquisition Act. Section 5A only expressed that yes, after the notification under section 4 of the Land Acquisition Act is issued, the person who will be affected by the notification will have a right to be heard before the authority. And the authority having failed to follow the mandate of section 5A, the Honorable Supreme Court has struck down all the subsequent actions of the state and has said that the mandate of hearing the affected person under section 5A shall be complied with. and only then the subsequent procedure shall be completed. So that has been again reiterated, and it has been held that right to be heard is now a procedural sub-right of the right to property itself enshrined under Article 300A of the Constitution. The next of the rights is the right to a reasoned decision. The authority, state authority, after hearing a party affected, cannot simply say, yes, we have accepted your agitation, or we have rejected your agitation, but it is the right of that person affected to have a reasoned decision from the authority. And therefore, reason, as it is stated, is the soul of any decision. And there cannot be a decision, a body alive without its soul. And that's why reason has been emphasized in the case of Kolkata Municipal Corporation versus Bimal Kumar Shah. The other rights are these. The duty to acquire is, it is held that it is the duty of the authority to acquire only for public purpose. I have emphasized in the earlier part of this lecture that in few other judgments also, the Honorable Supreme Court has held that property of a private person can be acquired by the state, the power of eminent domain can be exercised by the state only for public purpose. This has been emphasized here, that it is the duty of the state to acquire only for public purpose. Then, of course, this is the next one, is one of the most important rights, and that right is the right of restitution, or the right of fair compensation, adequate, appropriate, fair compensation. So right of restitution or fair compensation, these are words which are not expressly mentioned under Article 300A of the Constitution of India, but the net of rights expressly stated in these terms, the right to property, this web of rights shall be now inclusive of these rights, which is the right of restitution or fair compensation. Next right is also a very important right. The experience of advocates has shown that sometimes the compensation that his client will get would become inadequate by the passage of time, by the passage of long time, when actually he will be receiving that money. And that's why this is another procedural sub-right of the right to property, that is the right to an efficient and expeditious process. There are enactments which say that the process once begun shall end within this much of time. However, those are only enactments. But then Article 300, now the legal right under the Constitution is now accepted, that the right to an efficient and expeditious process shall also be a right to property. The right of conclusion, that is the right of concluding and completing the process of acquisition. So we have seen many a times that the acquisition process has begun, but it has never ended. It has never concluded logically by the payment of the compensation to the person who has been affected by such beginning of the deprivation of his property. And therefore, this is one of the important rights of under the right to property, and that is the right of conclusion, the right of concluding and completing the process of conclusion. These are most important of sub-rights which have been emphasized by the judgment of the Honorable Supreme Court. This is reported in 2024. I request all of you should have a look at it. With this, I will not be taxing the audience here with a list of an exhaustive list of judgments. There are many judgments of the Honorable Supreme Court in various circumstances, in various situations and facts of variety of cases, that certain laws have been, principles have been emphasized, iterated, reiterated. Nonetheless, we cannot conclude, we cannot exhaust all the entire list here. Therefore, with your permission, I will conclude my lecture here with this note. The right to property is a constitutionally recognized legal right, though not a fundamental right. The state and its authorities cannot deprive any citizen of its property without following the requirements prescribed in law. Friends, history is resplendent with records of quarrels, battles, wars to agitate and protect the right to property. Laws have been made positively to avoid violation of right to property. We all should also endeavor to ensure that we become the forerunners of these laws and these rights being agitated in the courts of law for our respective clients. All civilized societies have throughout the history of mankind held property rights of all human beings as one of the most vital rights. The Constitution of India and the judiciary of this great nation has upheld this important right for us. Thank you. Hope we will all again see each other in another eruditive lecture by some scholar. Thank you, Mr. Vikas and Vikram and others.
Thank you. There's only one question.
Yes.
Do the retirement benefits and pension be constituted a right under Article 300 capital A of Constitution of India?
Sir, this is a very interesting question. Before the 44th Amendment, there is a judgment of the Honorable Supreme Court which has held that pension, which is nothing but a deferred salary, has been held to be a fundamental right of a citizen. Now, that law has been reiterated that pension is still, because it is your acquired right, it is nothing but deferred salary, and therefore it is a fundamental right. And the pensionary benefits, though not fundamental right, are still legal rights under the specific statutes. One can enforce that right under Article 226 also.
Thank you, Mr. Ameet, for sharing your knowledge. And thank you, Vikram, for associating with Beyond Law CLC. We will share the PPT after getting it from Mr. Ameet Deshpande on our website of Beyond Law CLC. Stay connected and you can log into the website for the further details. Thank you.